This video, of course, belongs to the more or potpourri category of my channel. The first part is a general introduction and explanation of the conditions leading up to the civil lawsuit I filed on my behalf. The reading of the actual complaint begins at around 10:58 of the video. The complaint is the first document filed in court, which contains the facts, the timeline, and details of the events, the law and legal bases for my case, and what I wanted the court to do. For those with knowledge of court procedure, please note that the complaint was amended 3 times. The initial filing occurred on October 31st, 2014 in Maricopa County Superior Court, State of Arizona, number CV 2014-096428, and I represented myself, pro per. Caption: Judy Kennedy Plaintiff versus Lisa J. Stearns, MD, and John Doe Stearns, wife and husband, Jennifer S. Kaiser, PAC, and John Doe Kaiser, wife and husband, Antoinette Mirando, FNP, and John Doe Mirando, wife and husband, Center for Pain and Supportive Care, PLLC, and Arizona Limited Liability Corporation, and Medtronic, Inc., an Arizona corporation, and Doe's 1 through 10 defendants. Before I begin, I'd like to reiterate that Medtronic continues to manufacture dangerous medical devices that cause more harm than good and that claim the lives of many patients who are already suffering and sadly turn to them and compliant doctors who put profits before people in violation of their sworn oath, ethics, and duty to do no harm. Hi, this is Judy, your Wayward Muse. As promised, I am going to let you hear an audio recording of the complaint I filed in my lawsuit against a doctor and Medtronic for almost killing me, and because of my disability, which is PLS, primary lateral sclerosis. PLS is a disabling degenerative neurological motor disorder. It lives in the brain and spinal cord, but affects the lower extremities. PLS is the little sister to ALS, but non-fatal. It's in the same group of incurable diseases, but it's a rare one. Therefore, not a lot is known about it because medical research sources always promote the bigger, more pervasive illnesses like cancer. At this point, I want to give a big shout out to all the doctors and researchers who do contribute much or most of their time to this rare disease. It is truly appreciated. I have my own ideas about the causes, which I will discuss elsewhere eventually. And I also don't believe it's incurable. It's just that they haven't found the cure yet. That's all. Treatments consist in just the management of the symptoms. And those treatments are medication and sometimes physical therapy. In most cases, notwithstanding miracles of energy healing, which can and do occur for those with multidimensional awareness, it remains chronic and progressive, if not consciously countered with a management program to keep it plateaued, so to speak, which is what I do. I'm determined to stay unconfined to wheelchairs and only use them when absolutely necessary. At this time, I use a cane and must use electric carts at stores to get around. I can't stand on hard surfaces for any real length of time without succumbing to weakness and horrible pain. Pain is the big symptom for me. Pain and spasticity. Pain with me is moderate to severe. My management techniques are private for practical concerns. In other words, I don't feel comfortable sharing them at this time because I'm not that fond of judgment and being judged. Perhaps at a later time I'll talk about it, but not now. But there is one option I tried and it almost killed me. An intrathecal pump manufactured by Medtronic. The pump was deemed defective by the FDA, who ordered Medtronic to stop manufacturing it. I sued them and the doctor responsible for administering this option. I am responsible for choosing to ignore the warnings and my intuition, but I was in so much crippling pain that I was willing to take the risk. Intrathecal pumps automatically inject opioids and antispasticity medication straight into the spinal cord for immediate relief without the debilitating side effects of those medications, like drowsiness and addiction, among other things. For a supercharged creative already impaired by a sleep disorder like myself, it seemed like a godsend at first. For some people, mainly cancer patients on their deathbeds, it is. But my doctor was pioneering a so-called off-label use of the pump and was even partnering with Medtronic in these efforts. To make a long story short, the pump was defective and overdosed me 3 times to the point of coma, where I lingered on the doorstep to death before I was finally saved by the grace of my holy guardian angel through my husband and an ambitious, caring pulmonary doctor from Poland. That's what this is about. The details are in this complaint that I'm about to read that I promised that I would read in the other video. Now, I want you to ignore the legal terms that you don't understand. Again, I want to say this is not legal advice. I did work as a litigation paralegal for over 20 years. I represented myself in Superior Court, Justice Court, and federal courts. So I know how to construct these complaints. And while the form might be similar, the law may have changed since then. So if you have a concern or you wish to represent yourself pro se like I did, I would advise you to see an attorney first, just to make sure you know what you're doing and you're willing to go that route. My lawsuit would have won had I been able to hire an expert to testify on my behalf. That is the problem with the court systems today. They say that you have the right to represent yourself in court, the constitutional right, but then they make all these requirements that people, poor people especially, cannot afford. Though the evidence was obvious and spoke for itself, that's res ipsa loquitur, it's a legal term, no lawyer would take my case because they could not make money off it. The legal system is such that experts are required to testify to the accuracy and authenticity of medical records, and experts cost an inordinate amount of money. Then the other side hires their own expert to counter yours, corrupting the whole process, because then those experts become whores arguing against science instead of for it. Theories become more important than the facts, which get lost underneath the muddling word warriors' distortion of such basic concepts of law and justice by their incomplete, out of context, so-called legal arguments. Then there's the fact that I was already disabled with no lost income to claim. That's where most of the awarded money comes from. They could not put a large enough money value on my damages to make it worthwhile for them in terms of monetary profits. Even though my losses were substantial, as you will hear in the complaint that I recorded way back in 2014, just for my own purposes. Actually, that was a study technique that I had in graduate school of recording my notes and then playing them over and over, and that was made it easier to remember because you memorize facts that way and you can talk about them spontaneously instead of always referring to a piece of paper. Helps you on tests, etc., etc. But anyway, so I recorded the complaint way back then, and that's what I read to you in the following the last part of the video. So a complaint is the first document that you file in a lawsuit to bring about an action against another person or corporation or whatever. So yeah, in spite of those damages, I decided to represent myself. I'd done it before, just not in this particular area of the law. So I had to do a lot of research in the areas of law pertaining to this case, which were medical malpractice and product liability. While I did not win the case, I won a significant argument against Medtronic, which other attorneys began to use in similar cases. And this was an oral argument. Mine was superior, as was my performance in the courtroom, to that of the elite lawyers hired by Medtronic. It was so funny. Anyway, the reason I did not prevail was because the court would not allow me to proceed without those experts. even in light of the fact that their insistence upon that requirement is unconstitutional, considering that I was pro per and could not afford them. One day the law will change to accurately reflect the values of fairness and true justice. But that day was not my Ginsburg day. Watch the movie On the Basis of Sex, if you haven't already, about one of our most precious heroines, national treasure, Supreme Court Justice Ruth Bader Ginsburg. But I wasn't devastated. I knew the odds were stacked against me from the very beginning. I just couldn't feel good about myself unless I tried. When the judge wrongly dismissed the case, I set it all aside and was grateful that at least he just dismissed it instead of demanding a motion for summary judgment or something where the other attorneys would be awarded fees and costs. And that would have been really difficult for me to honor. I was proud of the fact that I conducted myself with complete restraint and decorum in the matter, unlike my first major case in Superior Court of Arizona, Kennedy versus Gallagher and Kennedy from 1996, otherwise known as Catwoman versus Gallagher and Kennedy. Having suffered brain damage at the hands of the defendants this time, literally, I just didn't have the time or the bandwidth for all the creative drama I could have inflicted upon them to make my points publicly. Therefore, sadly, entertainment value does not exist in this case. It was a complete tragedy, what my husband called a real life mare. And while I've healed from their wounds to a large degree, some permanence remains: trauma, short-term memory loss, and other cognitive deficits. And that's why I want to make the case and my complaint available to all and anyone who may need assistance in similar matters. I learned so much from this experience, and so can you. But first, the required disclaimer. This video is for informational purposes only, not intended as legal advice. A copy of the complaint should be in the description below. If not, you can find it on my website somewhere. I might put the link in here later. Anyway, I just wanted to say enjoy if you can, and good luck. If you do anything like this, please consult an attorney. Make sure that you know what you're doing. And as always, happy trails. Complaint. Background and general allegations. Plaintiff, Judy Kennedy, Judy, has a disability stemming from a rare and curable disease called primary lateral sclerosis, PLS, a variation of ALS but not fatal. PLS is treated by managing the symptoms, which for Judy are predominantly spasticity and moderate to severe chronic pain in her lower extremities. In 2010, a medical device manufactured by defendant Medtronic, the Medtronic SynchroMed 2 model 8637-40 intrathecal pain pump, the device, was surgically implanted in her lower right abdomen to help manage these symptoms by infusing the medications baclofen and bupivacaine directly into the spine for more immediate and thorough relief. As Judy's pain and spasticity increased, she was eventually referred to Dr. Stearns at the Center for Pain for the inclusion of morphine into the pump. While Judy was a patient at the Center of Pain, she was treated by Dr. Stearns, Ms. Kaiser, and Ms. Mirondo. As the pain continued to worsen, an X-ray revealed that the catheter had become dislodged. Surgery to replace the catheter and revise the pocket was scheduled for October 31st, 2012. In October 31st, 2012, at Scottsdale Healthcare Shea Hospital, SHS, Dr. Stearns performed the aforementioned surgery on Judy with the assistance of Ms. Kaiser and with 3 Medtronic sales representatives observing: Shauna Bennett, Dell Anderson, and Allison Rowley. Ms. Bennett spoke to Judy and her husband John before the operation and asked if they had any questions. At that time, Judy did not know about the device recalls, or she would have had questions about those issues. After coming out of recovery, Judy fell asleep and was not rousable for over 24 hours, at which time her speech was incomprehensible. Despite Dr. Stearns adjusting the pump more than once, Judy lapsed into a coma and was rushed into ICU. Judy spent the next 7 days suffering delirium, pain, emotional distress, severe thirst, and the inability to communicate these problems to anyone. Dr. Stearns suggested that her speech and cognitive impairment might be due to conversion disorder, but the other doctors and a consulting psychiatrist proved that theory totally false. The ruling consensus documented in the medical records several times over clearly reiterates that Judy's altered mental state, fever, hypoxia, and hypercarbia were directly due to oversedation from the pain pump. Judy was discharged on the 10th day, November 9th, 2012. Judy and her husband were never told what really happened, only that the medications had not been, quote, balanced, unquote. Judy had chronic nausea and a feeling of general malaise up until she returned to the Center for Pain on December 18, 2012, the date set for her pump refill. Ms. Kaiser discovered that the reservoir volume in the pump did not match the interrogated reservoir volume, a known sign of pump dysfunction and one of the reasons for its recall. Ms. Kaiser wrote down that this was probably due to incorrect value programmed at the time of the operation, and that they would monitor it closely. Ms. Kaiser told Judy that the medication should take effect in about 18 hours, and to be sure to call if she experienced any problems prior to that. In less than 8 hours, Judy was outside feeding her duck, when the next thing she knew, she woke up in ICU at SHS, not knowing where she was or how she got there. Approximately 17 hours had lapsed, hours lost to amnesia from the assault on her brain as a result of the overly infused medications from the defective pain pump. However, these hours were thoroughly documented by her husband and the ER staff at Chandler Regional Hospital. When it was obvious that Judy needed emergency medical attention, John called Dr. Stern's office as instructed by Ms. Kaiser. It was after hours, and the answering service told him that it would probably be an hour before he heard back from Dr. Stearns. Judy and John live approximately 40 miles from the nearest hospital. He did not want to wait around for Dr. Stearns to call him back or for an ambulance to arrive, so he decided to take Judy to the hospital himself. On the way to SHS, Judy became unconscious, and so John detoured to the emergency room at Chandler Regional Hospital, which was the nearest hospital to his current location. After ordering routine tests, Dr. Gregory Massoud, the emergency medical doctor at Chandler Regional, called Dr. Stearns for advice on how to deal with the pump. Ms. Morse answered and told him to put a magnet on it and to stop it from overinfusion. However, when Dr. Stearns finally returned his call, she told him that, quote, the patient did this a few months ago. She was seen by neurology and psychiatry, and it was felt to be a conversion reaction, unquote. Judy and John were shocked to read this in the medical records because it amounts to reckless misconduct antithetical to a medical doctor's Hippocratic oath. As previously noted, the medical records are very clear on what actually transpired during the first hospitalization, and there was no conversion disorder ever. If Dr. Massoud had not reasonably formed his own medical opinion and decided against treatment based on Dr. Stern's false erroneous statement, Judy in all probability would have died. Fortunately, Dr. Massoud put the magnet on the pump and began to administer oxygen and Narcan for overdose. Afterwards, ambulance transport to SHS was arranged for higher level care. During the second involuntary emergency hospitalization at SHS, Judy suffered hypoxic ischemia encephalopathy, metabolic toxic encephalopathy, seizures, PLEDS, frontal lobe stroke, sepsis, respiratory failure, prolonged coma more than once, emotional distress, and much more, all secondary to medication overdose from the defective recalled intrathecal pump manufactured by Medtronic. The diagnosis and etiology is confirmed time and time again by the treating doctors, the medical records, and even by Ms. Mirando in her notes. Judy was hospitalized the second time for 17 days. After the first 4 days, during which time she missed her husband's birthday, December 21st, she was out of ICU and had recovered well enough from the initial assault to be discharged by Dr. Stearns. On the morning of December 22nd, Dr. Stearns refilled and made final adjustments to the pump and told Judy she could go home that evening. Judy was understandably afraid, however, and needed more assurance that she did not have a ticking time bomb in her belly. Fortunately, Dr. Lou Palaskis, a pulmonary specialist, wisely intervened and suggested Judy stay one more night for an oximetry and sleep study. Relieved, Judy agreed. Less than approximately 10 hours later, a nurse finds Judy out of bed in extreme distress, covered with blood, due to lines and tubes being ripped out, and babbling nonsensically. She then collapsed and stopped breathing, whereby the staff called a code blue. This was the third, final, and worst assault yet by Dr. Stearns and Medtronic, resulting in Judy's longest internment in ICU. Judy fell into a critical condition so extensive and a coma so deep and prolonged that palliative care was called in. Several times the medical records reveal that Judy's Glasgow coma score had fallen to 3, a level of severity in which no one is expected to recover. One of the neurologists told John that it was as if someone had taken a baseball bat and repeatedly struck her head with it. He also stated that they did not know if Judy would come back, and if so, how much of her would be there, if at all. Needless to say, this was no way for anyone to spend the holidays, let alone Judy. Judy did come back, and not without having suffered debilitating damages and permanent traumatic brain injury. The medical records indicate time and time again that these injuries were caused by the pain pump and Dr. Stern's mismanagement of it. More than one doctor noted that the pump should not be turned back on. In fact, Judy got noticeably better after the pump was permanently turned off and filled with saline until such time that she could choose to have it turned back on or removed. Judy has decided to have the pump removed once she receives the funds to do so. In fact, per a notice published by Medtronic regarding the Class 1 recall, Medtronic states that the pump should be recovered if it has shown signs of failure, as hers certainly did multiple times. In the hospital, when Dr. Stearns was confronted with the question of why she had not called Medtronic in to assess the situation, she laughed and replied that whenever there is a pump with a problem, Medtronic calls her. She indicated that she helped design them and that she is the world's leading expert on how to manage them. Dr. Stearns knew of the danger and possibility of overdosing patients with these pumps as early as 2009 because she co-authored an article entitled Mortality Associated with Implantation and Management of Intrathecal Opioid Drug Infusion Systems to Treat Non-Cancer Pain. She has received much recognition and support for her research, including speaking fees. Most of these research studies are funded by Medtronic and include her name as a co-author. The publication in question then must reveal this obvious conflict of interest under the abstract. The FDA warned Medtronic that it may have waited too long before recalling the SynchroMed 2 pumps, thus placing patients in grave danger. In addition to the recall and the recalls of many other Medtronic devices that have resulted in product liability lawsuits in the past few years, the U.S. Securities and Exchange Commission, SEC, is investigating the company over the practice of paying doctors to recommend its products and consulting fees and providing them with other perks as well. As Dr. Stearns is admittedly, on her part, one of their top doctors, it is probable that she is intimately involved in these schemes. This deadly alliance and or partnership gave rise to conduct unfitting for a doctor who couldn't help but betray Judy's trust and best interest in this matter. Judy never received warning or notice by her previous physician, Dr. Stearns, or Medtronic about the recall of the device and its potential failure as required by the Food and Drug Administration, FDA, in spite of them all still having her correct address. As previously noted, the catheter attached to Judy's spine had become dislodged. In addition, after the surgery, Dr. Stearns told Judy's husband that she found blockage and a mass of scar tissue that had formed around the dislodged catheter tip. After Judy's discharge from the hospital on January 9th, 2013, she terminated her relationship with Dr. Stearns and commenced post-hospitalization rehabilitation and care with other medical providers. First cause of action, negligence, medical malpractice. I'm not going to read all allegations set forth above or incorporated by reference. From October 31st, 2012 through January 9th, 2013, Defendant Center for Pain, Dr. Stearns, Ms. Kaiser, and Ms. Mirando breached the applicable standard of medical care owed to plaintiff Judy, which approximately caused physical injury to Judy, along with pain, suffering, and other damages in an amount to be determined by the court. Second cause of action, medical malpractice, Respondent Superior R/Agency. Defendants Dr. Stearns, Ms. Kaiser, and Ms. Mirando, as employees, servants, agents of Center for Pain, deviated from the applicable standard of medical care, which was the direct and proximal cause of physical injuries, medical expenses, pain and suffering, and other damages to plaintiff Judy. Defendant Center for Pain, Dr. Stearns, Ms. Kaiser, and Ms. Mirando, as actual and or apparent agents of defendant Medtronic, deviated from the applicable standard of care, which was the direct and proximate cause of physical injuries, medical expenses, pain and suffering, and other damages to plaintiff Judy in an amount to be determined by the court. Third cause of action, negligence, breach of informed consent. The consent form signed by plaintiff Judy says, all risks and benefits reviewed with the patient. That statement is in error. Judy was not apprised of the pump's recall or any other problems or concerns specific to that model or the catheter, as was known and well documented in notices and reports released by Medtronic. Dr. Stearns, as a medical doctor and agent for Medtronic, knew of these risks, which were omitted from disclosure to plaintiff Judy. If Judy would have known about these particular risks, she would not have consented to the catheter replacement and pocket revision. Instead, she would have insisted that the pump be removed, as Medtronic recommends in their recall notice. In addition, the consent form signed by Judy allowed for only healthcare observers to be present during the surgery for the purpose of advancing medical education. The Medtronic individuals present, Shauna Bennett, Del Anderson, and Allison Rowley, were all Medtronic sales representatives as stated on their online corporate profiles available to the public, not healthcare workers. To plaintiff Judy, having allowed Medtronic agents into the operating room only adds insult to injury, like salt to a wound that continues to fester to this day. Therefore, Dr. Stearns, the Center for Pain, and Medtronic breached the standard of informed consent due to plaintiff Judy, which resulted in traumatic injuries to Judy and adds to her damages in an amount to be determined by the court. Fourth cause of action, negligence, silent fraud, fraudulent omission, misrepresentation. Defendants Dr. Stearns, Ms. Kaiser, Ms. Mirando, Center for Pain, and Medtronic all shared a duty to plaintiff Judy to fully disclose material fact about the medical procedure and the medical device pertinent to the procedure, specifically that the model pump in question was subject to a Class 1 recall for many reasons, and that the catheter was known to have problems as well, and that as long as these devices stayed inside Judy, she was vulnerable to profound injury and even death as a result of these devices failing. In addition, Judy requested Dr. Stearns' medical records, including the printouts of the pump telemetry. Interestingly, the telemetry data for the period during her hospitalizations was missing. This same allegation over missing data was also made in another lawsuit against Dr. Stearns for a similar incident. All these acts and omissions constitute conduct below the reasonable standards of care in the medical profession. 14 deaths so far have been associated with the failure of these devices manufactured by Medtronic. Yet defendants were also silent on these issues in order to protect themselves and their principal, Medtronic. Judy relied upon their failure to disclose these omissions and misrepresentations throughout her whole ordeal, thus suffering catastrophic injuries, near death, and permanent damage to her well-being. The specific amount of these damages will be determined by the court and may also include punitive damages. Fifth cause of action: reckless misconduct, erroneous diagnosis, failure to diagnose. All allegations, Defendant Dr. Stearns engaged in reckless misconduct when she told Dr. Massoud over the telephone that Judy was, quote, doing, unquote, conversion disorder, because that's, quote, what she did before, unquote. Conversion disorder was an erroneous diagnosis then and while Judy was in the hospital previously. All medical records contradict this completely false notion. By her erroneous statement to Dr. Massoud, Dr. Stearns was endangering Judy by running the risk of undermining Dr. Massoud's own diagnostic process and creating doubt and bias when there should be reason and objectivity. The action is elevated to recklessness when considering the actual condition that Judy was in: unconscious, not responding to the Narcan, and near death in a hospital emergency room. Dr. Stearns, as a medical doctor, is supposed to do no harm. She consciously disregarded a substantial and unjustifiable risk that her misconduct would result in significant damage to Judy. Her misconduct was a gross deviation from reasonable standards of medical care, breaching the duty owed to Judy in this regard. Throughout both hospitalizations, there were multiple signs and symptoms indicating that the device was failing. Dr. Stearns failing to recognize this fact constitutes negligence in failing to diagnose. Not owning up to what was actually happening could also have been another attempt to protect her partner, the principal, Medtronic. In another lawsuit against Dr. Stearns for an almost identical incident, Dr. Stearns' medical assistant took the fall for plaintiff's overdose by stating that she misprogrammed the pump. When Judy was in a coma, Dr. Stearns approached John, Judy's husband, and suggested that Judy be moved to the Barrow Clinic at St. Joseph's Hospital because, quote, every time I touch her, I hurt her, unquote, Dr. Stearns' exact words. This admission and bizarre behavior is another instance of reckless misconduct because moving Judy while she was in such an unstable condition to a hospital where no one knew her history could greatly jeopardize her treatment and recovery. Fortunately, John disagreed with Dr. Stearns and told her the problem happened at Scottsdale Hospital Shea, and so it should be fixed there. Again, it is difficult to imagine why Dr. Stearns would suggest such a thing at all unless it was pretextual, perhaps another effort to protect Medtronic and herself in order to muddy the issue regarding liability. All these actions on the part of Dr. Stearns fell below the reasonable standard of medical care, and so breached her duty to Judy, causing her damages in an amount to be determined by the court. Sixth cause of action: gross negligence. The Secramed pump has been classified by the FDA as a Class 1 recall, meaning there is, quote, reasonable probability, unquote, that it could cause serious health problems or even death. This is the most serious recall the FDA can give because of the potential for life-threatening complications, as is plainly seen in the case before the court. The FDA and Medtronic have identified several ways that the device malfunctions: priming bolus, overinfusions, problems with the battery, electrical shorts, and problems with pocket fills, refill kits. While it is not possible to know the exact underlying mechanism leading to the pump's predisposition to overinfusion without removing the pump, it cannot be denied that overinfusion took place and that most all of Judy's injuries were secondary to that overinfusion. The overinfusion of opioid medications cause respiratory failure and conditions constricting the flow of oxygen to the brain, resulting in traumatic permanent brain damage. The pain pump can only be managed and refilled by specialized medical providers who have exclusive control over these devices. Plaintiff Judy suffered the symptoms of overinfusion overdose 3 times. One, in the hospital immediately after the surgery by Dr. Stearns on October 31st, 2012. Two, immediately after Ms. Kaiser refilling the pump in the Center for Pain on December 18th, 2012. And three, immediately after Dr. Stearns refilling the pump on December 22nd, 2012 in the hospital. Dr. Stearns and Medtronic put Judy in ICU 3 times, each time nearly killing her and leaving her with catastrophic injuries from which she will never completely recover. It does not take a rocket scientist for any other expert to see the causal relationship here between their actions and the resulting harm to Judy. In fact, there's no other way in which these injuries could have occurred. As the theory of res ipsa loquitur plainly states, the thing speaks for itself. The court need only determine the specific amount of damages to be awarded. Seventh cause of action, strict product liability. Medtronic is a corporation with subsidiaries, offices, affiliates, and factories all over the world, in which engages in the design, manufacturing, marketing, and distribution of medical devices. A Medtronic Synchromed 2 intrathecal pain pump, model 8637-40, was surgically implanted in Judy's right abdomen in the summer of 2010 for controlling chronic pain and spasticity with the infusion of the drug baclofen. In 2012, Judy was referred to Dr. Stearns at the Center for Pain for the inclusion of morphine into the pump. As Judy's pain continued to worsen, an X-ray revealed that the catheter to the pump had become dislodged from her spine. Surgery was scheduled for October 31st, 2012, to replace the catheter and revise the flesh pocket holding the pump. Dr. Stearns replaced the dislodged catheter with a new implant, Catheter Ascend Lot N353441004, catalog number 8781, manufactured by Medtronic Neuro, one of the many Medtronic companies. Her assistant, Ms. Kaiser, helped with the pocket revision. Then the pump was filled with baclofen, bupivacaine, and hydromorphone, a morphine derivative. What happened next is summarized in the background section of this complaint and thoroughly documented in the medical records. The pump began to fail by overinfusing the medications into Plaintiff Judy, causing her to experience symptoms consistent with overdose: weakness, drowsiness, vomiting, seizures, respiratory failure, and coma. Judy was overdosed essentially every time Dr. Stearns or one of her assistants tampered with the pump, namely on October 31st, 2012, December 19th, 2012, and December 22nd, 2012. Judy's injuries became more extensive each time, eventually causing a frontal lobe stroke, leaving her with permanent traumatic brain damage. As soon as the pump was totally turned off, Judy's condition improved remarkably. Medtronic has issued several recalls recalling of their pain pumps. However, the one most relevant to Judy's is a Class 1, meaning that the use of the defective product can reasonably cause serious injury or fatality. At least 14 known deaths have been associated with these devices. Judy was almost the next one. Her condition had degraded to a point where palliative care was called in. The Medtronic Synchromed 2 intrathecal pain pump, model 8637-40, was defective in design, workmanship, construction, manufacture, marketing, and testing, and investigation of component parts like catheters, and as a result was defective, unsafe, and inadequate for the use for which it was made, intended to be used, and was being used. Because of this device's defective design, workmanship, construction, manufacture, marketing, testing, and investigation of component parts, it was inherently dangerous and capable of causing serious bodily injury when placed inside of a human being, and as a result was unreasonably dangerous to potential users and to Plaintiff Judy. Defendant Medtronic, including Dr. Stearns, knew or should have known that this device would be used as was intended, but nevertheless permitted the purchase and use of this device in patients like Judy, who were unaware of its dangers, hazards, and peril. As a direct and proximate result of the defects in this device and its failure to perform safely, and of the failure of defendants to give plaintiff Judy adequate safety warnings of those defects, Judy sustained serious and permanent bodily injuries as described above. Eighth cause of action, breach of implied and express warranty. Defendants are jointly and or severably liable for the injuries to plaintiff Judy for the resulting damages from the defective device, and that it was defectively designed and manufactured, and in a defective condition when sold to plaintiff Judy, thereby violating the implied and express warranties which were attached to and accompanied this device. Defendants assured plaintiff that this device was free from defects in material and workmanship. Dr. Stearns expressly told Judy that the new catheter was better than the old one. These assurances and statements created an implied and express warranty that the device would conform to expectations and be safe for use in the manner for which it was intended. Plaintiff Judy relied on the skill, judgment, assurances, and statements of defendants and their implied and express warranty as specified above. As a result of the defects in material and workmanship described above, defendants breached their implied and express warranty that this device was in a marketable condition, safe for use by ultimate users and consumers, and in particular plaintiff Judy. As a direct and proximate result of the breach of implied and express warranty by defendants, and each of them, plaintiff Judy sustained serious and permanent bodily injuries as set forth above. Ninth cause of action, negligence per se. Defendants marketed its medical device by using deceptive acts and practices, false pretenses, false promises, misrepresentations, and by concealing, suppressing, and omitting material facts in connection with the sale and advertisement of this device. Defendants intended that others rely upon such deceptive acts and practices, false pretenses, false promises, misrepresentations, and concealed, suppressed, and omitted material facts. Plaintiff Judy suffered damages as a result of her reliance on defendants' deceptive acts and practices, false pretenses, false promises, misrepresentations, and concealed, suppressed, and omitted material facts. The implantation, surgical revision, and adjustments made pertaining to this defective device by defendants were the cause of Judy's physical injuries and damages. Defendants' actions, therefore, were wanton, reckless, and exhibit a blatant indifference to the health, safety, and interests of others, especially Judy. As such, punitive damages are appropriate against defendants to deter similar conduct in the future. Defendants' actions are and were violations of the Consumer Fraud Act, ARS Sections 44-1521 through 44-1534. As a direct and proximate result of defendants' negligence and recklessness, Judy suffered critical injuries requiring extensive medical treatment and incurred substantial medical expenses. For example, memory loss and persistent cognitive and emotional deficiencies are just some of the injuries for which she has been treated as a result of these damages. Her neurologist stated that these injuries could take years to recover from and may never completely resolve. Studies show that traumatic brain injury like Judy's is linked with a higher risk for developing Alzheimer's disease and a tenfold increase in stroke risk. She has already suffered from one such stroke during her second hospitalization under Dr. Stearns' care. Moreover, other studies show that women who suffer a severe traumatic brain injury like Judy have an 8 times higher risk of dying within 10 years after the injury. It is important to remember that before these injuries, Judy already suffered from a physical disability. The serious injuries caused by defendants not only added to and compounded that physical disability, but gave her new ones to deal with in the form of decreased mental and emotional functioning. Therefore, it is highly probable that Judy will require further medical treatment and incur such expenses in the future for which she is entitled to reasonable compensation from defendants in an amount to be determined by the court. Wherefore, as a direct and proximate result of all of defendants' actions listed in this complaint, Plaintiff Judy suffered general damages including permanent traumatic brain injury, shortened life expectancy, pain and suffering, anxiety, emotional distress, personality change, memory loss, a diminishing of emotional and cognitive skills, loss of earning capacity, and extensive medical expenses. Other damages include future medical expenses, future caregiver expense, pump removal surgery, continuing disability, and continued pain and suffering. Therefore, Plaintiff Judy asked for judgment against the defendants and each of them for an amount that will justly and fairly compensate Judy for her injuries and damages, for the cost of suit, and for such other and further relief as is just and proper. Judy also respectfully asked that punitive damages be awarded for the benefit of one and all. Pursuant to ARS Section 12, 2603, Plaintiff Judy certifies that based on her current understanding of her claims, expert opinion will not be necessary to prove them. Plaintiff Judy demands a trial by jury. Respectfully submitted this 31st day of October 2014.